And that leads me to the last topic of my presentation, which is the cost submission. And here again, on an international scene, there is no uniformity in practice regarding cost submissions. You will find very different ways to do that. And I've summarized the three main ways that I've experienced in my arbitration practice. The first is what I would call, and please don't quote me on that, these are just casual terms to help you understand what the cost terms actually mean. So the first one is the light cost schedule. And by that I mean that the parties just file the list of costs. They may or may not add the invoices, and they don't add any legal argumentation, so they just send in the list of all the fees and expenses they had. This works if you are in the environment where lawyers trust each other. So for example, if in an international arbitration, we as a Swiss law firm are engaged and the other party is also represented, let's say, by a Swiss law firm or a German law firm or a French law firm that we are familiar with, that we trust the lawyers and we trust that they don't overly increase their costs or cheat on the invoices. If the level of trust between the lawyers is high enough, then you can go with that light scheme and say we just file the list of our fees and expenses, but we may not even need to file the invoices, and there's no legal argumentation. We agree on the loser pays it all and the discretion of the tribunal, and we leave it up to the tribunal to decide. That is a very practical way to go for small arbitrations. It's not worth, spending days putting together your fees, your invoices, and all the rest on small amounts, small dispute amounts. The second is what I would call the more standard cost schedule. It's still just a list of costs, but this time with the invoices. And very often, especially if the trust among the parties is affected and also among the lawyers, some of them will require proof of payment. So on one side, you not just have to file the invoices, but you also have to file the proof that these invoices have been paid. And very often these standard cost schedule will include a basic legal argumentation referring to the applicable rules in the arbitration rules, where it deals with the cost allocation, and a very basic argumentation why one party or the other should bear the entirety or part of the costs. The third way I've experienced, I've seen in practice, is what I would call the full cost submission. And here, not only do you provide a list of costs, not only do you provide the invoices in support of this list of costs, not only do you provide proof of payment of the invoices you've submitted, but you also qualify and explain why you believe your costs are reasonable and maybe why the cost of the other party is not reasonable. And you provide full-fledged arguments on the allocation of costs with reference to legal sources, case law, scholarly books, articles, etc. So in practice, actually, you can really bump into these three different layers of complexity of cost schedules. Another thing to keep in mind here is that there will also be a difference in practice between having only one round of cost submissions, where both parties file the cost submission at the same time, and two rounds, where actually each party gets to comment on the other party's cost submissions. In the situation of light cost schedule, so the first situation we have here, usually it will just be one round, and there will be a second round only if one of the parties is suspicious about certain costs listed, okay? Then it will maybe ask for proof, invoice, or proof of payment, or ask more details about a specific cost item. With the standard cost schedule, it's usually the same. That will also be one main round with the possibility to object if some costs listed appear to be suspicious, or if the other party wants to get certainty about the extent or the nature of specific costs claimed. If we are going with full cost submissions, you can be pretty sure that the parties will require a second round to be able to comment on the full-fledged legal argumentation of the other party, including also the qualification of whether certain costs are to be deemed reasonable or not. And with this, actually, it concludes my presentation, and I hope you enjoyed it. I hope you learned a little bit about costs, and that you will take away some of the explanations and advice I gave you. I wish you a lot of joy and pleasure in this international arbitration world, and it would be my honor to bump into you in a real arbitration case very soon. Take care, stay healthy, and God bless you.